All right, good morning, everyone. We'll get started with our webinar. It's 10:30. Thank you for joining us. I'm Greg Harford from the Canberra Business Chamber, and I'm very pleased to be joined today by Annalise Hansen, a workplace relations consultant who's previously worked in internal HR positions, understands business needs and understands compliance, more importantly. So she's one of our advisors, provides advice to a large range of clients about workplace laws and the management of workplace matters. So we're going to be talking here today about the right to disconnect, which has been enacted as part of the federal government's changes to workplace relations laws. The format of this is that Annalise is going to give us a short presentation on what the right to disconnect means, and then we'll have an opportunity for questions at the end. So if you do have any questions, please use the Q&A function at the bottom of your Zoom screen, and we'll get to those at the end. But Annalise, I'll hand over to you for now.
Wonderful. Thank you so much. Look, there is a little disclaimer at the start. It's pretty self-explanatory there, so I will just head on and keep moving forward. So looking at this right to disconnect legislation, it is a part of a few bills that we've seen pass. So on the 14th of December, several changes to the Fair Work Act legislation came into effect. Given the breadth of these changes, it was decided to split this bill into two components. So in the Closing the Loophole Bill number 2, which includes this legislation here of our right to disconnect, we see a very interesting concept coming into play. Now, this specific amendment arose from a Greens proposal from a specific member, Barbara. This amendment will be effective the 26th of August 2024, or if you're a small business, which means that you have a business with less than 15 employees, for you, it's effective 26th of August 2025. Now, I think it's important that we actually understand what this means and how do we manage a concept like this in our business. So here is a smaller breakdown of the 2023 changes which have occurred and the timeline. I'm more than happy to share this around for you to review following this presentation if you want to have a look at this breakdown and the timeline of this. Now, looking at the right to disconnect. So in simple terms, the new right allows an employee outside of their working hours to refuse to monitor, read, or respond to contact, which is calls, texts, emails, or attempted contact from their employer. Now, this right also extends to third-party contact, such as a client or a customer trying to get a hold of this employee. And the right to refuse cannot be exercised if the refusal is unreasonable. So what it's not, so you obviously can't be sending an email or text to your employees outside of work. You can't be calling them. And it's important to note as well that the penalty for this one is not of a criminal offence, which we see with some of the changes in the way that they have passed recent legislation. And then, yeah. Okay, so in terms of the actual clause, this is an excerpt from the first reading speech, which is basically what this legislation will be looking like. To summarize, it's basically what I had explained before. And it's quite important to note that it's a right to not do something, not that they necessarily have a right. So this gives this employee the choice to exercise it. Probably from that, we're not going to see every employee wanting to exercise this right to disconnect. It doesn't prevent them from putting in additional hours if they choose to, but it ensures that if they make the choice to exercise this right, they are entitled to refuse unreasonable contact outside of designated working hours. Now, as a result of an employee's right to disconnect from work, now that this is included as a workplace right, for the purposes of general protections, which is something that we have two separate things when we look at a claim being made. It can be that someone goes to the Fair Work Commission, or they might make a general protections claim, which would say that the business is taking, let's say, adverse action, or they're discriminating for any basis. Now, for the purposes of this legislation, what we'd be looking at is that the business is taking adverse action on someone's exercising the workplace right, which would be their right to disconnect. And you might be taking adverse action on the basis of that, which would mean you're, doing disciplinary action or you're terminating their employment, and they could make a claim on that basis. So when we're understanding a piece of legislation, I think it's really important to understand the actual intent behind it. And what we do is we would go to the Parliament's second reading speech to understand what is it that they actually intend, because the right to disconnect is such a broad term. And I guess there's so many different interpretations as to what does that actually mean for me. So in Barbara's speech, she talked about that our current workplace laws were not drafted at a time when everyone had a smartphone in their pocket and a laptop with internet connecting their kitchen table to their work site, which is really the driving factor for bringing in this amendment to the Fair Work Act. So in her speech, she gave a few examples of who this bill might apply to. The first example of people that she gave was people in an insecure job. Now, that would be that they're needing to wait for a text to let them know that they need to come in early the next day, or what their site would be for the next day, or also that ability to accept shifts, which is what we'd see in a casual natured employment. Now, she relates this to effectively being on call without receiving the allowance, as you need to remain available in order to secure sufficient paid work to get by. She also stated in saying if an employee doesn't answer, they may not get offered as many hours the next week or get offered any shifts at all. Now, forecasting this is where I'm seeing that we might see some adverse action claims coming in. Now, whether there's actually weight behind that is, I'm unsure at this point, because if you look at someone like a casual employee, that is really a defining nature of their role, in that ability to accept and decline shifts, because that business has an inability to guarantee the fixed working arrangement or guaranteed hours. So that's definitely going to be something interesting to see how that's taken, because she's made that comment as an intent behind the legislation. Now, second, she gives an example of full-time and permanent employees who are constantly checking their texts and emails outside of working hours. And she talks about the fact that this is really detrimental to people with competing responsibilities, being that they might be a parent and then they're also trying to balance work, which is where we see the additional consideration of family or caring responsibilities when understanding if a request is unreasonable, which we'll go through in a little bit. So, to understand whether a test is unreasonable, we have an evaluation to have regard to a few factors. And we need to be creating a paper trail for any dispute processes in the case that this does arise. So, for the employees who may be contacted out of hours, the business needs to evaluate how their teams/their job fits into the out of hours connection hierarchy. So is it critical? Is it just very important? Is it important? Is it good to do, or is it helpful or somewhat helpful or unnecessary? So that might be a really good way for us as businesses to determine, okay, in the case that this legislation comes into effect, who is it that I really need on call per se after hours, and who is it that it might not be so necessary for them to be contacted out of work? And when we understand that, we can strategize as a business what we need to do for the people that are quite critical to be available after work. What are the mechanisms that we need to have in place to make sure that we're safe and we are preventing a claim from arising? So without limiting the matters that may be taken into account in determining whether a refusal is unreasonable, there is a following few factors that we might be looking at. So the reason for the contact or attempted contact, how the contact or attempted contact is made, and the level of disruption to the contact of or attempted contact. So that would be something like evaluating a call versus an email. Is one of them more disruptive to somebody's out of hours? And we would need to be assessing what is the best way for us to manage that if we do need to get in contact with someone for something that may be more critical, or one of our more critical employees that need to be contacted. The extent to which the employee is compensated. So this also takes into account any non-monetary compensation afforded to the employee. To remain available to perform work during the period in which the contact or attempted contact is made. For working additional hours outside of the employee's ordinary hours of work, the nature of the employee's role and the employee's level of responsibilities, and the employee's personal circumstances, which is where I said before, including our family or caring responsibilities. So that's something that the Fair Work Commission will be taking into consideration when people have those competing responsibilities. So to give you an example, it would likely be considered reasonable to expect a high-level manager. Now, that's not saying someone like our Woolworths supervisor. It's more a director of operations or our general manager to respond to more urgent emails, whereas the same probably wouldn't apply to an entry-level administration worker. Now, when understanding, I guess it's a good thing to understand in the case that we're getting into a dispute with an employee, how is this actually going to be handled by the Fair Work? So there are various avenues for dispute resolution in circumstances where an employer believes that an employee's refusal to monitor, read, or respond to contact or attempted contact is unreasonable. Now, this might include that they're encouraging us in first instance to attempt to resolve it between the two parties. In the case that we can't come to some sort of resolution and we need to engage someone external, then we look at making an application to the Fair Work Commission. Now, the grounds that you'd be making an application would be making an order to stop refusing contact or to stop certain actions or otherwise deal with the dispute. So the Fair Work Commission may make an order if they are satisfied that either or both of the following apply. So 1, an employee has unreasonably refused to monitor, read, or respond to contact or attempted contact, and there is a risk that the employee will continue to do so. Or an employee's refusal to monitor, read, or respond to contact or attempted contact is not reasonable, and there is a risk that the employer will take disciplinary action against the employee because the employer's belief that the refusal is unreasonable, or continue to require the employee to monitor, read, or respond to contact or attempted contact despite the employee's refusal to do so. So that's where we'd be seeing the Fair Work Commission basically making an order in those instances where they feel as though there is a danger to one of the parties. Now, the right to disconnect does not prevent you or a third party ringing an employee, texting them, or sending an email outside of working hours. Because as I mentioned earlier, it's the right to not do something, not a right to do something. So that means that in the case that you were to send an email, which I think in the way that we strategize as businesses, we should be evaluating how we can mitigate the risk of a claim arising. But let's say in the case that you choose to do so, it's just that that employee has the right to refuse to read it, not that they actually have a right in the first place. Now, whether a refusal is unreasonable will be contextual to the individual circumstances. So we're looking at how, when, why, who. There are a number of factors specified in the Act to have regard to determine this, whether the refusal is unreasonable, as I mentioned earlier. Now, the right applies to all employees covered by the Fair Work system, including award and enterprise agreement-free employees. So that's just because someone, you might have your enterprise agreement in your organization doesn't mean that this won't apply to them. And the right operates for the purposes of the adverse action, which I talked about a little earlier in our general protections claims, provisions of the Fair Work Act. Employers and employees will be able to go to the Fair Work Commission to deal with disputes about this new right, no compensation. The Fair Work Commission will have a test case this year to include a clause in modern awards dealing with this new right that I believe is coming out in July. So we'll get a little bit more of an understanding what that's going to look like in our modern awards, and we can strategize a little bit better when we have an understanding of what is it that they're actually going to write in the awards. And how might that affect the way that we currently conduct business and us, I guess, re-strategizing as managers in mitigating the risk of a claim arising. So what is it that I actually need to do? And I think this is the most important thing because we need to make sure that we're implementing mechanisms into the business to make sure that we're mitigating the risk of claims arising. So first of all, we need to assess the workplace impacts and differentiation of engagement in the workplace if we're taking away this expectation that people are not engaging outside of working hours. We need to consider current working structure. So what are our hours of work in order to know what is outside our work hours? Because these will really be determined by the hours that we set or the hours set in an award. So for example, our Health Professional and Support Services Award or our Retail Award has that stipulated ordinary hours in the award, which is a lot easier then because we can use that as a point of reference when determining if we're going outside of those hours. So we need to expand, reduce, or alter what are an employee's hours of work to which they have the right to disconnect or it doesn't apply. Perhaps expressly address the importance of having to monitor, read, or respond to contact or attempted contact outside of employees' working hours. And we can have those clauses in contracts to say that we address that there is this legislation. This is how the business determines how that takes effect in this business, and this is how we're dealing with that. Now, express reference to senior roles and the remuneration benefits associated with their disconnecting at certain times. One of the lawyers in our gave a really good example about this, in the sense if you look at someone like Scott Morrison when the bushfires happened, and he had, I guess, exercised this right to disconnect when he went to Hawaii. And we're looking at, okay, someone that is of that senior position, I guess logistically speaking, they really don't have that right to disconnect because their role is to look after the nation. And when we're experiencing bushfires, it's not appropriate for someone like that to disconnect. And that's a really great example of understanding that, yes, if we look at it from a black and white perspective, it does say people have the right to disconnect. But I think that we need to look at, okay, who does this actually apply to and who do we need to account for that can exercise this right to disconnect? It's a good idea to also include a definition of its meaning in the contract. This can avoid getting into disputes with employees when they feel as though they have this right to disconnect. I think a great thing about the internet is everyone can become aware of things and research about things, but sometimes we find that we get into disputes with employees because they have thought that they have something that applies to them, or been their own researcher on the internet, and then we're getting into disputes with somebody that doesn't apply to. So by having that defined in the contract, it's a good way to have that as a point of reference and saying, this is who it applies to. We understand that the legislation is here. This is how we're dealing with it. It's important that the business evaluates the importance of particular types of out of hours contact. So what is actually necessary and who are the necessary people to be contacted? Another good way to deal with this is if we have large management teams, investing in doing some training with them and understanding what their do's and don'ts are, and establishing as best as possible how can we address this right to disconnect and have a broad and uniform approach to this. Now, they also need to be aware that they will be prohibited from engaging in adverse action against an employee. So that would be, as I said before, let's say we performance manage someone because they're not responding to our texts outside of work. Well, someone could then make a general protections claim. So in that sense as well, we also need to look at helping our managers to stop these knee-jerking responses where somebody will say, your performance expectations are based on me working around the clock. They could say something like, it's not my fault, I turned my phone off. I feel stressed with these emails I get sent and feel like I have to read them or else I'll get in trouble. You can't ask me to do that now. I'll only look at it tomorrow. If you paid me more, I might be interested in doing. It's not a dereliction of duties. I have a right to disconnect. Now, these are not really claims that we want to be having to deal with. And in that sense, we need to train our managers to prevent these from happening in the first place and making sure that we're not getting into these disputes with employees when they have that ability to make a claim that we might be breaching our obligation to let them disconnect. Now, the other thing as well is reviewing these modern award changes when they come in effect. I believe the Fair Work Commission has something like 155 awards to be amended by the 25th of August. And they've identified 11 award terms which they're really going to need to relook at. So this is things like our on-call allowances, reasonable overtime, things where we see averaging working hours. So you might work 152 hours over a certain period, and then you might do 20 hours one week, 40 hours the next week. So they're going to need to look at, okay, if we're doing averaging hours, how is that going to come into play with our right to disconnect? These draft terms, as I mentioned earlier, they'll be published on the 15th of July. So we can have a little look then to see, okay, how is this going to affect my respective award? Is there anything that I need to change, or am I all good for the moment? And then the final determinations will be on the 23rd of August, and we'll be able to see definitely what it's going to look like when this legislation is coming into play. And I think I'll hand over to Greg to run some questions.
Thank you very much, Annalise. I think there's a couple of questions coming in there, but can I just clarify one thing? There's been quite a lot of discussion, I think, around this new right to disconnect, and sort of part of the key messaging, I think, is that it's a right not to respond to things. But in the piece of legislation that you showed us, in fact, it said an employer must not contact an employee outside the employee's hours of work unless there's an emergency or there's an availability allowance being paid. So doesn't that kind of contradict that and say, well, actually, you can't contact your employee at all unless you're paying them an allowance?
Yeah, and I think that's where we come into our unreasonable assessment, because when the Fair Work Commission will be determining if that contact is unreasonable and it's not something, I guess, that is an emergency or genuine welfare matter, that, okay, who is the person that we're trying to contact? What is the reason? Now, keep in mind as well, this clause came from the first reading speech. So it will be interesting to see if they add in further clauses about that. When the first reading speech is done, it's basically saying, hey, this is the bill that I want to enact. Then it goes through all of the debating process, going to the different houses. I probably think that there will be in the awards further clarification about that unreasonable assessment, in the sense that senior employees, it doesn't necessarily need to be of an emergency. But again, I think it is making it quite clear that those senior employees should be able to disconnect too. And in that sense, if we're just texting them all the time or wanting them to do things that aren't really that urgent, well, we might be being a little bit unreasonable there. And it might be that a claim does come about in that sense.
And my sense, Annalise, is that most employers are trying to do the right thing anyway. Employers aren't sitting there bombarding their employees with typically with text messages or emails out of hours. So there's always a reason for it. If I understand correctly, what you're saying is that it is really about you can send an email potentially to your employee. It's just that the employee is not required to respond to it.
And as well as us as managers, a lot of our day, particularly if we're working in a busy organization, is you're there for the employees and they ask you a lot of questions, and then it delays you from doing what you need to do as well, which means that you need to work out of hours to get what you need to do. In that sense, what we're seeing that a few of our businesses that we've worked with that want to get on the front foot of this, what they're doing is they either put a disclaimer in their email saying, hey, just letting you know, I work at this time. You're not obliged to respond to my email at 1 a.m. However, I'm sending the email at this time. Or we just use our buttons like schedule send. If we're sending our emails at 1 a.m, just let them all launch at 9 a.m. Everyone will think that you're so productive because you're sending 20 emails in the space of 5 minutes. But really, you've just schedule sent all these, and you did it, that morning when you had some downtime and you were uninterrupted.
All right. There's a couple of questions that have come in. Is there any accommodation for small business? Is there any exemption that applies for small business here?
At the moment, the only thing we've seen for small businesses, you do get a delay of it coming into effect for a year. So for everybody else, it's August this year. And then for the small businesses, it will be next year. But in terms of from next year, unfortunately, it does apply to everyone. It's not that the small businesses will be exempt. I think it's also important to come back to the fact that it's not a right to do something, it's a right to exercise that in the case that they want to. So let's say you're a small business, everyone's happy to work a little bit outside of work hours, they want to work that additional overtime. That's fine. That's completely fine for them to do that. But in the case that they turn around and say, you know what, I don't want to be contacted after 6 p.m. I want to spend time with my children. I want to be on the Saturday morning soccer. That's also fine for them to exercise that right. And next year, for the small businesses, they will be able to do so.
Okay, thank you. So, in terms of that small business delay, what's a small business for the purposes of this? Is it under 15 employees?
Yeah, you're absolutely correct there.
Okay. All right. Look, the other question, we might wrap this up shortly. So if you do have any more questions, please just do drop them into the Q&A function. But is it different if I'm sending a text or an email? Do the same rules apply, or is there a difference?
That's a really good question. And I think it comes back to the fact of understanding what is the type of communication that we're using. Now, from a broad standpoint, what it's saying is that it's no contact, but I think in the case that you do need to contact someone, there is more appropriate forms of contact than something else, in the sense that I think that an email would probably be less invasive than something like calling them, because that is immediately a lot more disruptive. But again, we need to be looking at, okay, what is it that we're wanting to contact them? If we're just wanting to send an email that they can look at the next day, again, you can just put a disclaimer in it and say, hey, sending this email now, don't expect for you to respond to this until 9 a.m. tomorrow. And then that's fine. It's not disrupting them. And also, you can put a message into the organization and saying, look, we pay for people to have Outlook on their phones, but we don't want you to put that on your personal phone if you feel as though it's seeping into your personal time. In that sense, it's available to you and the business pays for it, but there's no expectation for you to have that downloaded on your phone. In that sense, you can send emails to their work emails and they can just see it when they log into their computer at 9 a.m. the next day.
Thank you. All right, any further questions from our audience? Last call for questions here on the webinar. And if not, Olivia Hanson, Annalise Hanson, thank you very much for your time this morning and for your insights. There's obviously a few complexities in this that businesses are going to be working through over the next few months. August is the deadline for anyone with more than 15 employees, and August next year for any small business with fewer than 15 employees. So if you do have any further questions, please do reach out to the Chamber's Workplace Relations support team. You can get us on 1300 277 881. Otherwise, I hope that's been useful, and do just reach out with any questions. Annalise, thank you very much.
Thank you so much.